So my name is Ellen Harrison. My husband and I signed a gas lease before we knew anything about shale gas development, thinking we shouldn't be NIMBY after all, we use energy, etc. And then we found out about what kinds of impacts shale gas exploitation has, and I didn't sleep for about 3 days and decided the first thing you want to do is hide under a rock, and then decided we had to do something. So formed Fleeced. We are beginning to get some national interest in the unfair leasing that's gone on. Both a pretty high-power newspaper and a pretty high-profile environmental organization have been asking me for people that they might call to learn about their stories. So if you would indicate whether you're willing for us to share information or not. So I'm going to ask Joe to start this and pass it around, and if you are interested in signing up for Fleeced, please do. Briefly, on our website, which is pretty primitive because I'm the person who's handling it and I don't know how to do it, there is information that should be of use to you, things like a template letter. If you get a force majeure letter from a gas company, you need to respond. And there's a very simple letter that we ran by a bunch of attorneys. There is the packet that Joe, working with others in the state, have put together on lease termination. It's on our website as well as GDAC's site. So you may find things that are useful there. There is a survey that you can link to if you're online. And basically, the survey is painful to fill out because it asks you to take a close look at your lease. And most of us don't want to look at our leases again. But it is designed to gather the information we need so that we can tell these stories and get, hopefully, somebody to take some action. We've been working with the Attorney General's office. We're fortunate that the new Attorney General ran on an anti-fracking campaign. And so we've been meeting and talking with their office, and we have certainly been talking with legislators and others. So we are trying to keep from feeling hopeless and impotent and see what we can do. And there's a lot of us out there, and there's power in numbers. So most of us felt pretty ashamed when we realized what a crappy deal we signed up for. And I'm urging you to move from shame to anger. We were duped, and we deserve better. How many of you have seen floating around on the internet a talking points handbook that was put together for landmen? So landmen are the guys who came to your door, knocked on your door, told you what good guys they were and what a great deal they were getting for you. And one landman dropped his book on a driveway in Ohio. And it is a good read, I'll tell you, because you're going to read it and say, oh yeah, that's just what he said. So the kinds of things that one is pressure, 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 get them to sign today, because if they have time to think, they're less likely to sign. This is a big one, sell it as patriotic. It's local energy. What they don't tell you is by now, large percentages of the gas companies are owned by international companies. China, India, Norway, Denmark. And what they also don't tell you is, of course, this is a capitalist system. The gas will go where they get the best price for it. They are now trying to get pipelines to get it down towards New York City and build a liquefied natural gas processing plant with the idea that basically you compress the gas, you turn it to a liquid, you put it on ships, and you take it to Europe, wherever you're going to get the best price for it. But they sold it on patriotic, and apparently there are nice signs around saying, bring a soldier home, develop natural gas. So that was one talking point. Another is, oh, we're a small local company. What they don't tell you is gas leases are then sold. So a local guy, they don't have to tell you if they sell your lease. You have to go find out. And one guy found out that his lease is now owned by 6 different companies. So they also in the book say, tell them that we're looking for oil. Well, they could look for oil. Most of the leases would allow them to look for oil, but that isn't why they were signing us up. They knew about shale gas. Don't discuss the chemicals. If somebody brings up water pollution, divert it. Don't answer the questions. If somebody says, how many wells are we talking about? Don't answer the question. If somebody says, how many wells can you have on a well pad? Don't answer the question. Don't tell them that to develop a major well pad, it's probably going to be 20 acres, and it'll get down to 5 acres by the time we're actually in operation. Just mention the 5 acres. Tell them their neighbors have signed, even if their neighbors haven't signed. Tell them that they're being bad neighbors if they don't sign. They'll be stymieing everybody's desire locally. Tell them that the lease is for 5 years. We'll talk a little more about that. Most leases may have a 5-year original clause. Then there's a 5-year right to renew that's strictly on the gas companies. They can do it if they want to. And then if there's any activity on a spacing unit, we'll talk about that in a minute, you're held. And the mortgage lenders in Tompkins County have basically said, we consider a lease forever. And I'll tell you, the more I learn, the more I feel like I signed a pact with the devil. Water usage, most people don't know that we're going to pull local water. The radioactivity one is wonderfully tricky. We don't add or use anything radioactive. Well, that's true, but the radioactivity is in the shale. And so when you pull the water or pull the cuttings up from down below, they are radioactive. So they don't lie to you by saying they don't add any radioactivity, but they are they're misleading you. And it turns out that it seems like legally, they're not allowed to lie to you, but they don't have to tell you the truth. So this is Joe's line. The first paragraph in most leases sets forth what they have the rights to. And as Joe said, it's basically everything, including your firstborn. I had my lease reviewed by a lawyer, but he didn't know anything about this stuff. This was long enough ago, not that long ago. He knew nothing. So he didn't point any of this out to me. So a standard lease. Now, again, most of us who signed most of us who signed a lease that was pretty much what the gas company brought to our door. Yeah, we made a few little changes in it. I did. I don't know if you did. But fundamentally, it was a standard lease. Now, people are getting smarter and banding together in these landowner coalitions. And one thing they're doing is getting a lot more money than most of us got. And they are hoping, but they haven't signed yet, to get more environmental protections on their property and less intrusion onto their property in various ways. And, there's a question, can you get a good lease? Because some of you, if you end up getting out of your leases, may consider whether you want to release. Personally, no way. There is, to me, no way that you can have a good lease. You're not going to outsmart those guys. And beyond the impact on my own personal property, I believe that the community impacts are horrendous and huge. And there's no way that a good lease for a single person is going to protect us from those community impacts. So in general, you've conveyed all the oil, gas, mineral, whether hydrocarbon or not hydrocarbon, you've leased those mineral rights, and they can use whatever methodologies may come about in the future. So the fact that we didn't anticipate high-volume slickwater hydrofracking, well, too bad. They can go ahead and do that. And if nuclear technology is approved, well, they could do that. A standard lease says they can explore, develop, produce, measure, market. And they generally have the rights to construct pipelines. They have the right to construct compression stations, which are something you wouldn't want on your property. They also have the right generally to store gas, and that storage may be from gas taken from anywhere. It doesn't necessarily mean it's your gas. This was something, this is fairly late breaking and interesting. In Tompkins County, the mortgage lending community has been meeting with some of the county officials, the tax assessment office, and some local attorneys. And most mortgages are sold on the secondary mortgage market. So it's, you get a mortgage from such and such a bank, but then they sell your mortgage elsewhere. And it turns out that the secondary mortgage market standards tend to be driven by Fannie Mae and Freddie Mac. And under those programs, there must be at least a 200-foot setback between a residential structure and, it's a little unclear, a well pad, not exactly clear. But what we're finding in Tompkins County, according to our mortgage lenders and people I know, is somebody wants to buy a property and it's a leased property, they can't get a mortgage. Because at this point, the setbacks are not 200 feet. And in fact, to have a federally insured mortgage, you need a 300-foot setback. And if you draw yourself a little radius around it, that's basically 5 acres. You need 5 acres carved out. The gas companies have no reason to do that. Why should they do that? So it's not happening. We met with the DEC, and it just blew my mind. The current setback is 100 feet. That's 100 feet from the well, not the edge of the well pad, 100 feet from the well to a residential structure. I don't know, what's the distance? Here to the stained glass window? I mean, it's nothing. 150 feet from a school or a church. And are you all familiar with the draft supplemental impact statement, TSGIS? Basically, that was DEC's proposal of by now a couple of years ago for revising some standards. Same setbacks. Just a joke. And when we met with DEC and said, you can't get a mortgage under these, they said, well, mortgages aren't our problem. And we said, well, what do you think Fannie and Freddie are basing their standards on? I'm assuming there's some environmental reasons here. So again, we're pushing on this because it's insane. Another thing that completely blows people's mind is the gas company's rights to the surface of your land trump your rights. So whatever you have when you signed up for the lease, that's yours, you'll keep it. You want to put up a new barn? Do it at your own risk. The gas company can come along and say, that's just where I wanted to put a drill pad. You no longer have control of the surface of your land. So when does a lease end? I don't know, at least for me, not soon enough. You sign up for a primary term, that's usually 5 years, sometimes it's 3 years. And then there's an extension of the primary term. That's the one where usually they have a right to renew. They can sign you up again without your saying anything, yes or no. And then if there's any activity, and that's not defined in most leases, does that mean putting in a road, or does that actually mean putting in a well? What is an activity? And you may have to go to court to define whether it's an activity. It's probably a judge would look and say, well, how much money did they spend? How reversible is it? But once they have initiated activity on a unit in which any part of your property, your leased property, is part of that unit, your lease is held open. Joe is going to talk, I think, right, Joe, about force majeure, so I won't talk about that. But it's another way that the gas companies are seeking to extend leases. So what is a unit? Do you guys heard of a unit and you're being unitized? That's usually in a lease. So the dark line, the rectangle, shows a, quote, spacing unit. When a gas company wants to get a permit from DEC, they have to propose an area that is a spacing unit. That can be as small as 40 acres, but these days with the horizontal slickwater hydrofracking, tends to be about a square mile, which is 640 acres. And they don't tend to be square because they want to go with the orientation of rock fractures, and so they go long. And basically what would happen in this area is somewhere approximately towards the middle of it would be a drill pad. And from that drill pad, they would do 6, 8, 10, 12, 16 wells in which they go down and then go horizontal. So there'll be sort of like a fan sticking out up and down across the unit. And as you may know, within a spacing unit, if they apply to DEC, they must have control through leases of 60% of the land area within that unit. That's not 60% of the owners. Could be one landowner. It's 60% of the land area. The other 40% of that land, and all of the people who own that 40%, would be subject to compulsory integration. And Joe, were you going to talk a bit about that? Okay. The idea of compulsory integration is, like it or not, they can drill under your land, they can inject toxic chemicals under your land, they can take the gas from under your land, they have to pay you some royalties. And you can imagine that in general there are big landowners. So in Tompkins County, I think we're, 40% leased, and it's owned by 6% of the property owners, because it tends to be large landowners. So how do you know if you've been made part of a unit? Well, we shouldn't be surprised. You have no way to know. Nobody tells you. Nobody applies to you. You have to go check the DEC website. How often? I don't know. Often enough. You can search it by town, and it'll tell you when a permit was applied for, and then you can look at a Google map they're linked to and get at least some location about where it is, and then you have to contact DEC to hopefully get a spacing unit map to find out if you're in a unit. The only notification that's required is before they actually drill, they are to notify or construct, so it may include the drill pad. They have to notify the municipality and the single property owner on whose land they're going to be constructing, but not the neighbors, not anybody else in the unit. So as I say, the onus is on the landowner. One of the things I'm thinking is we need to get organized in our towns and counties so somebody is checking this on a regular basis, so you're not caught unawares. I mentioned that Fleeced has a survey. I mentioned that it's painful. How many of you who are leased do not have internet access? Okay. So I'm perfectly willing to send a hard copy of the survey to people, and then I can input their data if they're not on the internet. But if you are on the internet, I urge you to work with the survey. The actions that I want to urge you to take, we need to let people know. So the Attorney General's office, Joe and I and some others met with some of their people, and they were quite interested. But one of the things one of the guys said to me as a follow-up was, we need some stories. Not long, 2 paragraphs. What happened? What did they tell you? How were you fleeced? How were you taken advantage of, if you feel like you were? And we also need you to share that with the governor's office, because frankly, this is politics, folks. And we're facing a very mighty foe who has a huge amount of money. But I have been incredibly impressed by the strength of the grassroots. And we are voters. We have power in that way. So we need to get our word out there. We also need to put pressure on our state legislators. I'm very fortunate that Barbara Lifton, who's my legislator, my assemblywoman, is behind a lot of legislation that would be protective in various ways. but she can only propose it. It has to get passed by others. So when you write up a short thing of your story, send it to all of those people. They need to hear it. I think at that point I'm going to stop, and as I say, get over feeling ashamed, get over feeling that it's hopeless, and get angry. Let's start working on this. Thanks.
Well, I want to thank all of you for coming tonight, and hopefully we can help you learn a little bit more about your lease and the problems that you may have when it comes to the time when you hope that it will terminate. Most of you have probably seen pictures of frac pads. This is a picture taken in Pennsylvania within the last year. So when we're talking about setbacks and how close they are to your house, I have a private well, probably most of you do. This is what you need to think about. This is not your grandfather's gas well. I think that's what we've all learned over the last couple of years. And I want to, just as a way of introduction, what I'm going to try to cover tonight is you really should think carefully about extending an existing old lease, whether you want to lease again or whether you want to get out of it. Some of the unfavorable terms, if you've really read particularly that first paragraph in your lease, most of that you didn't know you were agreeing to. I think the one that gets the neighbors that have come to my house with their leases, I live in Cortland County, we'll come back to that in a minute, is the storage of gas from anywhere under your property. That's not what most of the people that leased were thinking about. Certainly the finances have changed, and we've learned a great deal about the environmental problems that have been caused in Pennsylvania, in West Virginia, in Texas, in Wyoming, in Colorado, New Mexico. And what we've learned recently in Cortland County and elsewhere is that leases do not automatically terminate. Most people that have been thinking about their leases are calculating to that 5-year anniversary, thinking, well, I'm done with this then, and I can try to recover from it. That's not necessarily the case. In most situations, landowners need to take steps, and we'll cover those in the law and the processes. We're also going to talk briefly about the company's attempts to extend leases. Has anyone received what we call a force majeure letter, where the companies say incorrectly that they can extend your lease just by writing you a letter because of the state moratorium? We'll go over why that isn't accurate legally. There are some cases filed recently in Binghamton that will help us understand that. And we have some form letters on various websites that we urge you to send back to the company so there can be no confusion about whether or not you're accepting that letter. There are problems with what are called delay rental clauses. We'll go over that. The newer leases I've seen have a no termination clause, and we'll come back to that. Now, this is a map of what they call the shale plays. You know, some of the words in this industry are just Orwellian in nature. There's nothing playful about natural gas extraction. It's not natural gas, I'm sorry. I try never to call it. We don't call it natural coal. It's gas. It's a toxic substance. It's explosive. Most of the gas fields, it's not anything playful about it. But this shows you the size of the various shale formations where they have recently, in the last 10 years, discovered that they can go back and get gas that they couldn't before. And as you can see, this area, which is the combined Marcellus and Utica shale, we always hear about the Marcellus shale. So we're targeted, we're at ground zero here. This is a map of the Marcellus shale. Shale formations are closer to the surface in the north, and they go deeper to the south. They're named after the places they come out of the earth. Marcellus is Marcellus, New York. And so it's very shallow in some of the areas. And about a year and a half ago, I belonged to a volunteer group in Cortland called the Gas Drilling Awareness of Cortland County. We had a driller come and try to tell us, well, you don't have to worry about them drilling here because the Marcellus shale is too shallow. It's like so many statements that we hear from the company and the landmen. The beginning of it is true, and then the conclusion is an absolute lie. Why are they signing so many leases? This is the Utica Shale, 2,000 to 3,000 feet lower, and perfectly accessible in Cortland, Onondaga, all of these counties. So that's why they're leasing so heavily. As I said, I live in Cortland County. This is a map prepared by our planning department. The brown areas are leased. 48% of our county is leased. The green areas, which you'd think would be safe because they're state forests, some of those have already been leased. And so that creates a conflict in the DEC. They are required to promote the extraction of this resource, then turn around and regulate it. That's enough of a conflict. And then they lease our public wealth for profit. It's the same three conflicts that the MMS had that led to the Deepwater Horizon disaster. And then to make this even harder to accept, when you look at the leases that the state drew for themselves, we found one in 2008 in one of these state forests in the southern parts of the county. It has all of these protections built in that we'd all kill for to have in our leases, and they never bothered to put it on their website saying, you should think about this. Like, you can't cut a tree without my written permission. You can't put a well anywhere without my written permission. You can't extend the lease without my written permission. You can't assign my lease to another company that I'll later have to go track down, and we'll come back to that, without my written permission. So the lawyers for DEC, with the assistance of the then Attorney General, knew that there was a much better way to have a lease than the ones that most landowners get stuck with. They just haven't bothered to share that with us. So this is the extent of the leasing in Cortland County. Much like Tompkins, it's 48%, 8% of the landowners. And if you think, I like to cut that figure in half because about half the people don't own land. So 4% of the people have leased that much of our land, and we're that close to getting into that 60%. So what they'll do is they'll create spacing units, and we'll come back to that a little more, that will draw into those heavily leased areas. And the problem that we have, this is a sole source aquifer. What that means that for those of us, I'm lucky enough to live up on one of these glacial lakes here, my well draws water out of that aquifer. It's about 30 feet below the ground. One spill on a pad, that aquifer is ruined for the 50,000 or so people who can't get water anywhere else. There's not a proper protection for that under the current. I just want to explain that I have a little personal interest in this as well. And just briefly on my personal background, I've been a lawyer since ~75 in environmental and civil rights. I've reviewed scores of leases, actually, since I wrote this a couple months ago. It's several hundred leases. I've helped terminate 2 since November. Both of them, the landowners had to go through the process that we'll go over in a minute. I'm not looking for clients or more work, but we have done what we can to help people. And there's a certain point where you may need a lawyer, but hopefully not. So we've gone over pretty much the standard lease. So I can skip over some of the, this is the same kind of information that Ellen just shared with you. This is an interesting one, using the methods and techniques which are not restricted to current technology. They're now talking about fracking with propane at a pressure that's probably 10 times higher than your propane tank. So you can think of the what happens when one of those goes bad. They first tried to do this in the 50s with nuclear explosions underneath grounds out in, I think it was Montana. So they can do that under the standard lease. They can do anything under the standard lease. And of course, these are the standard clauses you give away. So let's think about your lease, what you should look at in it. So you want to look at your first paragraph. It's called the leasing paragraph. We just went over what's in there. You want to look at the extension paragraph and what they can claim extends a lease. You want to see whether or not there's a force majeure clause. Chesapeake, which is the main leaser over in Cortland County, sent a force majeure letter on January 26th, identical letters, I have about 40 of them in my file, to every leaseholder. At least 2 of my old friends in Marcellus, New York, don't even have force majeure clauses in their lease, and yet the companies send them that letter. And that's one of the practices that the Attorney General has tried to correct with other companies. So you want to look as to whether or not you even have a force majeure clause. We'll come back to what that means. Whether or not there's a delay rental clause. The standard lease that the landman brings to your door and tells you this is all you can sign it quick, almost always has an automatic extension where not only do they get the first 5 years, but merely by paying a set amount, they can extend it for another 5 years. You certainly want to know whether that's there. A lot of people, it seems, have crossed those out. And then, of course, there's the clause of the lease will operate as long as there are operations, not only within your land, and that generally means that they've drilled a well, but I hope we don't end up testing what that means, but also in a spacing unit, as Ellen explained. And we'll come back to that. So those are the areas that you want to pay close attention to. Most of these leases have incredibly small print. They have incredibly long sentences. My mother, who's not with us anymore, but she would have marked this up with a red pen. She was an English teacher. It's very hard to read one of these, as you know, and very hard to understand exactly what's in there and how the various clauses fit together. The law in New York State that governs lease termination is a portion of the General Obligations Law. It's Section 15304. And it starts out, it looks good when it starts out. The first paragraph says that the company shall send you a recordable document when the lease terminates. That's a nice statement. That's what they should do. The problem is it doesn't say what happens when they don't. There's no penalty whatsoever. There's no automatic termination when they don't. And it leaves the landowner in a very vulnerable and delicate position. And we'll go over that in a minute. You also see in bold and underline assignee. And we'll come back to what that means. And what's happened is that these companies are selling portions of their lease. They're overextended. Chesapeake is the second largest gas driller in the country, and yet they have a serious financial problem because the price of gas is so low. And so what they do is they play monopoly with your land and your water. They gather up enough leases. In New York, they sold 32.5% of all of their leases to a Norwegian company, Statoil. And just within the last week, another company just got a permit from the federal government to export gas off New Jersey into Europe and Asia. And what they're telling their stockholders is, we've come up with an answer to the problem that we have that the gas is selling too cheaply. We can sell it for twice as much in Europe and Asia. In the Fayette Shale, they sold that 32.5% for $3.7 billion. So that's what they do. They gather up all these little houses and hotels and put them together, and they win the game. In the Fayette Shale, which is in Arkansas, they sold all of their interest to an Australian company. This is all within the last 6 months to a year. They sold all of that for $4.75 billion. Now the Chinese are buying in, they say just to get the expertise so they can go over there, in fact, but all of these foreign companies are buying in. So this is the way to get us off the oil habit that comes from people we don't like, is not what's playing out. So what happens if the company doesn't send you this notice that it's supposedly required to? So then we look at the second portion of the law. And at the end of this, you'll see a website link to the Cortland group where all of this information and the forms that I'm going to refer to are contained, and we hope that those are helpful. So if you don't get the notice and your lease has, let's say you signed it May 11th, 2006, and now it's May 12th, 2011, and you don't have anything from the company, what do? Well, you may send a notice letter. And the problem with this is that sending this notice letter, and there's a split among legal people that we've talked to. We've talked to one lawyer from Elmira who's fairly knowledgeable, who recommends against sending the letter, because by sending the letter, you give the company, you open a window of 30 days where the company can then file an affidavit, and we'll come back to that. There are a number of factors that you have to weigh in whether or not you do that. That lawyer said that he will write title insurance in the situation. The problem is your peace of mind. Do you know whether your lease is over or not? Or is it still sitting there? Can you get a second mortgage? Can you get a home equity loan? Can you sell your property? Most of the time, you can't with a gas lease, because lawyers and title companies will not write title insurance. And we all know these days that because of the secondary mortgage market, title insurance is required in almost every sale. So there are a lot of reasons why you would want to get some closure to this, let alone the psychological relief that it would bring. But look at we're going to go through the details of what has to be in that lease, in that notice letter. The problem is that you not only have to send it to the original company, let's say Chesapeake, not one of my favorite companies given the way they bullied my neighbors, so I keep using them. Not only to them, but to any other company that they have assigned your lease to. Whether you know that or whether it's merely recorded in the county clerk. And you won't know it because they never tell people. In Cortland, one of our members of the gas drilling awareness group, his lease should have terminated in November. So he and I walked through this law together. He sent Chesapeake a notice letter. He waited his 30 days. Then we'll see what he was able to do. He goes to the county clerk, who's very against some of the practices of these companies. She and I gave a presentation in Cortland together about a week ago. She will not record these extensions. And we're getting more and more legal advice that she's correcting them. And she said, well, wait a minute, Mike. You should know that Chesapeake filed this assignment document, which is one document, with several hundred property owners listed in it, whose leases are then assigned. He had to then notify 6 companies before he got done. So you have to go to the county clerk, look at the original, look under the name of the original landowner that leased. Now, certainly, if any of you have come into property that had a lease before you purchased it, you need to send that company a copy of your deed right away. We had a question, some of these events blend together. I've been in Dryden, Cortland, but it doesn't matter. Somebody asked, well, what happened to me was that I called the company as to why I hadn't gotten any notice, and they said, well, we sent the extension check to the original landowner, and that person cashed that check and extended the lease that was then on the subsequent buyer's shoulders. And that's legal, unless you send them your lease. So if you have inherited a lease or purchased property with a lease, send them your deed. And then they can't buy off the prior owner. So you have to send these very carefully worded notice letters, not only to the original company, but to all assignees. And it needs to have a whole lot of details in it. We have one on the website, which I think is user-friendly, but people have used them successfully. You want to send that return receipt requested. You also want to put together an affidavit of service, which is merely a statement saying that on such and such a date I mailed this. We have a form for that on there too. This is what you have to put in your notice letter. You don't just send them, oh, Chesapeake, my name is Joe Heath, here's my lease, it's terminated, send me my notice. That's what the statute ought to say. And just remember how much you have to do here when we come back to how little the companies have to do in order to extend. So you have to put your name and address. These are not unknown. It's just tedious that you have to go through all of this. The name and address and interest of the person sending the letter if you're not on the lease, the county, the state, the town of the leased property, the location and general description of the leased property. If you're in a unit, the name and description of that spacing unit. If there's a well, the name and number of the well, the date the lease was signed, the date of termination, and the basis for such termination. That's a lot. It's a pretty detailed letter. Then the company, either the original company that leased or the assignee, has 30 days. They can file an affidavit with the county clerk. Doesn't have to say anything other than this lease is extended. No reasons, no details, nothing compared to the burden on the landowner just to send a notice. Without sending the notice letter, you don't open that window, and so you're in a bind there. Do you send it or not? There's some factors to be considered there. Certainly, if you have one of these clauses that reads no automatic termination, I don't think you should sit back and wait, because that would certainly weigh against the lease terminating on its own. If you've received a force majeure letter, that's a claim by the company that your lease is extended. You're not going to get their agreement that it has ended without getting a notice. So if they don't file the affidavit in that 30 days, you take your copy of your notice letter and your affidavit of service, you run down to the county clerk on the 13th hour of that 30 days and file those, and the statute provides that that filing terminates the lease. And there's no further action that you need to take. Then you call your neighbors and have a party. Now, I've gone over this briefly, but one of the problems here is that you have to notify every assignee, whether you know who they are or not. So you have to go to the county clerk and find that out. We have samples of these letters on GDAC website. We'll come back to that. There are instructions and explanations, excerpts from the law we just looked at, sample notice and sample affidavit of service. Now, one of the problems is that one of the ways that leases are extended, as Ellen alluded to, is that if there are operations anywhere in a pooled or spacing unit. Again, this is probably the same spacing unit that she showed you. And this is something that really, I think, is pretty scandalous when you first hear about it. And everybody talks about landowners' rights and I can do what I want with my land and all of that, and we think that we have control of our land. Not if 60% of the people 60% of the area, if 60% of the area in a pooled unit have leased, they're going to drill under your land whether you want them to or not. Doesn't sound right, does it? It's a state law passed in 2005 on the last day of the legislature. It's one that we need to amend. It's one that doesn't even apply scientifically to this method of drilling, and yet it's being used, and it's going to be used a great deal if the DEC gets around to allowing these permits. And so I'm just going to talk about this briefly because it has a tremendous impact on whether or not your lease gets extended. If you're in a spacing unit that's been approved by the DEC and they drill a well on your neighbor, any portion of your property, okay? And they don't care if your property is all in there. Let's say you've got a 100-acre farm down here, and 1 acre of it is in the pooling unit, your pool. All of the lease on all of your 100 acres is extended if any portion of your property is in the pooling unit. So what you'll get, eventually, the company will apply for a spacing unit, and eventually the DEC will send out notices to the unleased owners. They'll tell you that they're going to hold a hearing in Albany. Now, that's better for you than it is for people in the western part of the state, but it isn't very convenient. It should be right here in the town. So they're going to hold a hearing, and then you're going to be given three choices. This gets really complicated. The first time I read this, I said, how do they expect you have 30 days to make this really difficult decision, really emotional decision, because you've just been told that you don't really have control of your property, and they're going to drill under your land whether you want them to or not, and you have to start making these complicated decisions about whether or not you're going to choose one of these three options. You can be integrated as a royalty owner, as a non-participating owner, or as a participating owner. So I'll just read through this briefly, and then there'll be a quiz afterwards. Integration as a royalty owner means you have no financial commitment or risk. You get low royalty payments after the cost of drilling is recouped. So that's really a do-nothing clause. You'll get some royalty. You don't have to put in any money. You have no financial risk. So the non-participating owner, you still have no financial commitment or risk, but you get no royalty payments. You get a higher royalty in this second option, but you get no royalty payments until the well produces and the company recovers the cost of drilling, your share of the drilling costs. Not only your share in one unit, but also 200% more of your drilling costs. So they have to recover 300% of your share of the drilling costs from the well before they pay you any royalty. Simple, right? Then the third is as a participating owner, where you pay your share of the estimated drilling costs, which is a significant amount of money. You have to pay that before the hearing in that 30 days. And then you don't get any of it back if there's a dry hole. So that's a brief overview of this very simple law that you may face in 30 days. Delay rental payments. If you get a check towards the end of your lease, be very careful of it. Return it. Tell them you're rejecting it. Keep copies. Probably need to start getting advice at that point. All right, force majeure letters. We think this is another dirty trick by Chesapeake and other companies. And this is an opinion that we've had some affirmation from the Attorney General's office. Every lawyer that I've talked to that's knowledgeable in this area, and they're getting to be more and more. Force majeure is a contract law clause. And basically, it's a major force. It's a French term. That's its literal translation. It's also referred to as an act of God. If I have a contract to build you a house, and I can't get to your house because as the road to my house does every spring because the clown who built it illegally through a wetland, it floods, and I can't get my trucks down there, that's a force majeure. It's an act of God. It prevents me from completing my obligation under the contract. That's the proper use of force majeure. If there's a problem with getting the materials because of a strike or they can't get them across the border or whatever, that's a force majeure. These attempts by the companies to use force majeure in this situation, we think, are not valid. And the excuse they use is that the state moratorium is in effect from last December until at least June 1st. These are not valid, and we'll go over that in a minute. 2 federal lawsuits have now been filed in Binghamton, where hundreds of landowners have bonded together to test this. Hopefully we'll get some rulings on those, although corporations are notorious in dragging out litigation and beating down individual practitioners who try to handle them. They dump truckloads of paper on you in what we call discovery. They do not want quick resolution to these cases because they are attempting to bully you, and they don't want a judge to rule that bullying attempt is not legal. So certainly we're keeping an eye on those. If you have received a force majeure letter, you need to write them back. And you need to say, I don't agree with you. If you only do that, it's much better than doing nothing. If some time has gone by, still write them back. We have a fairly elaborate, I think it's a 2.5, 3-page letter on the website. It's in Word. You're welcome to use as much or as little of it as you want. The important thing is, do not be silent, because they will attempt to use that silence against you later on. Here's the leading case in New York State. This is the State Court of Appeals. That's our highest court. This is the leading case on force majeure It's in another context, but it fits perfectly here. And this is 20. It's not new law. With the battery of lawyers that these companies have, they know this very well. And the Court of Appeals said, the purpose of contract law is to allocate the risks that might affect performance, and that performance should be excused only in extreme circumstances. They then talked about another attempt by the defendant to extend a lease. That was, they had claimed impossibility, which is another contract dodge. And then this second quote follows the rejection of the impossibility claim. Contractual force majeure clauses under the common law provide a similarly narrow defense, ordinarily only if the force majeure clause specifically includes the event that actually prevents a party from performance, will that party be excused. It's a very narrow, it tells us that force majeure clauses are to be used extremely rarely, and it's very narrow, and you won't find the word state moratorium in your lease. Now, you'll find some reference to acts of government, but it's the opinion of the lawyer who showed me that case that these are not worth. First of all, they're not prevented from drilling on your property now. They can drill into any other formation. The Trenton Black River, they can drill deeper into the Utica. There's gas in sandstone formations. They can do vertical fracking. They just can't do horizontal, high-volume, slickwater hydraulic fracturing in the Marcellus. That's the only thing that's covered by the moratorium. So they are not prevented from drilling under the moratorium. That's another reason. The other thing is there's been an effective moratorium since June of 2008. At that time, Governor Patterson instructed the DEC to come up with a supplemental generic environmental impact statement. It took them about a year, and they haven't been able to get permits for this since June of 2008. What's the excuse for waiting 2.5 years? So, other things that you want to be worried about, we've gone over pooling and compulsory integration. Operations anywhere in the pooled unit, we've gone over that. The new no automatic termination, this lease shall be construed against termination. If you have one of those in your lease, you've got to send a notice letter. There's no way that they're going to agree that your lease has been terminated. I don't think that's, I can't wait till somebody can test that in court also. You should also know that you have liability. If there's an environmental problem, the landowner has liability. And if you think about it, in the southern tier now, they're leasing for $5,000 and $6,000 an acre. They could buy the same acre for $1,000. There's a reason that they spend 5 times as much as they need to when they could buy it, and that's the liability. So you need to think about that. You certainly want to talk to your insurance agent about it. Problems with mortgages. So you want to be careful of those delay rental checks that come in the end. You want to respond to force majeure letters. You want to check with the county clerk about assignments. And you must you should think about acting to extend a lease. And you're in that dilemma. Do you send the notice letter and open that 30-day window, or do you sit back and hope that you can use your land without encumbrance, sell your land without encumbrance, until we get some legal rulings on the impact of that clause in the law. We've talked with Barbara Lifton and another assembly person from Syracuse, Sam Roberts, about amending that law. I don't know whether it'll get in this session, which is due to end on June 20th, but you can see that that's a very company-friendly and very burdensome on the landowner. We've made specific suggestions for how it could be done better. So there's the GDAC website. I think I have the Fleece website finally correct. And there are landowners coalitions, and there are other lawyers. And that's my email, and I think that's the remarks I wanted to give you, and we will now take some questions. So thank you for your attention.
If there is anyone here from Plymouth, I have a petition you might want to sign. Second item is that Michelle Kennedy associated herself with Zarin and Steinmetz, and they say they're open to entertaining the possibility of mounting a class action lawsuit, but they would be looking for 35 to 40 lessors, and they would be expected to contribute $2,000 to $3,000 each. So that will be a challenge. And the third item is that the local gas committee has invited Tom Shepstone to come to Norwich to speak on June 16th. And he is a walking conflict of interest. He is located in Pennsylvania. He sells himself as a planning consultant for towns, but he also is a paid consultant for Energy in Depth, which is a mouthpiece for the industry. And they have worked out a campaign which they call a grassroots campaign to hire local people to attend town board meetings where they understand that there will be talk of establishing local ordinances or controls over gas drilling. And their goal, of course, is to stop that and to institute ordinances that would be gas drilling friendly. Now that's Tom Shepstone, and he is due to be in this county June 16th at the gas meeting, and we might be able to mount a counter demonstration afterwards. It's quite a challenge, but there is a flyer, and it looks like this, and it's on the back table. Thank you for your presentations, by the way.
Thanks, Peter. One of the things that we have been hearing is this Energy in Depth, which is funded by the gas companies, hiring people to do grassroots. And that these people have been effective when they have basically gone to the media at the beginning of a meeting. So if perchance you are around at any of these, a couple things. One is, somebody needs to ask them who's paying them. And you need to talk with your media people if you're at an event to be sure that they're aware that somebody is paying them. Thanks.
Has the compulsory integration been challenged? Because if one steps back and looks at compulsory integration, it seems in my mind, now I'm not an attorney of course, but it's an illegal taking of property, and it would violate fundamentally the New York State Constitution. So I wonder what protections there are, and could we challenge this particular law?
Well, that was exactly my instinct when I first heard what compulsory integration is, and someone explained it to me. And then I had some people in my office do some research, and most of the law around oil and mineral rights, particularly oil and gas rights, most of the major decisions go back to the turn of the last century, about 1900, early 1900s. And we know how strong the corporations were at that time, particularly Standard Oil. And we have another lawyer who may correct me. I haven't found a lawyer who thinks that we can challenge compulsory integration, and it's, you know, it feels like eminent domain without being compensated. The problem is you get some compensation. And maybe the reason it's so complicated, you know, I didn't read all that's in, you can download from the DEC website this fact sheet, which I defy most of you to understand, but maybe the reason it's so complicated is that you're given 3 different price choices. So that's as fair as we can make it. We have not found anybody that's willing to challenge the compulsory integration law. And the reason it doesn't work, it's necessary for the old conventional drilling. It used to be that we drilled down, we found pockets of gas, not we, they, and it's like drinking soda from a straw. You put the straw in, you take all the gas out. You don't know where the limits of that are, and therefore, inadvertently, you take neighbors' rights. That's when compulsory integration is useful. They know very well, within millimeters, they tell us, where they're drilling. They could stop drilling on your land if they wanted to. It's not necessary for this type of drilling. Now, the fracking does extend a little bit beyond the drill bore, but they claim they have that under control too. It's a law that we should ask our legislature to change. It certainly feels totally undemocratic to me. I don't want somebody drilling under my land or mucking with my well when I have no say over it. So but we can't find anybody to challenge it.
Other part of the question was a little clarification of the roadside seismic testing. Now, it's my understanding that on many town roads, the person who owns the land alongside the town road essentially owns to the middle of the road and has given the town the right of way to drive trucks. But they were not given they did not sign over to the town permission to use a dynamite and other things that they use. So I'm wondering how that impacts, and I understand that it may be different in a county road or a state road where they own the property, perhaps under the road.
Well, we know that let's say your neighbor agrees to allow them to seismic test, you have no say in that. So I think if that's a question. It's probably you don't have a lot of rights, but I haven't ever really encountered that fact pattern before. So,
Right.
And the other thing I would say, seismic testing is not harmless. We have at least one well in the town of Preble, that's the town I live in, that was significantly impacted by seismic testing. This is, for those of you who don't know where it is, this is where they look for They do these small, controlled explosions on the surface, and it's essentially sonar. They get vibrations back, and somehow they locate the shale formations using this. Now, we found them, I live across a small lake, and Song Mountain is over here. We saw them flying helicopters up and down there, dropping equipment. And, well, what the heck is going on? 8 vice presidents from Chesapeake came. They never once told us what they were going to do when they got there. None of us knew what fracking was 5 years ago. Mm-hmm. But this is a line I've heard them use time and time again. Oh, we're not going to drill here. We didn't find what we want here. And you saw all those leases. They always say they're not going to drill here, which is another line of the company. I don't really know the answer to that.
It's an interesting question.
Good, thank you.
Hi, my name's Mary Jo Long. One of the things that I've been hearing from some of people who are leased, as well as from others who are not leased in the areas of southern Chenango County, are that companies are now coming around asking landowners to sign pipeline easements. And this is true even if for individuals where they have already leased, and in the lease it has included the right to have pipeline easements and lay pipeline for gas on the property. And it's, I've had a few people call me and say, well, why are they doing that? Or, of course, they ask the landmen or whatever they're calling themselves at this point, and, they don't get a clear answer. And I heard one attorney speculate that she thinks it's because the leases, the underlying lease, might get challenged, might run out, might not get renewed, might not stand a legal challenge. And so the companies are actually looking for a separate contract to protect their right to have a gas pipeline over land, because the gas pipeline is an asset. The right to put in a gas pipeline is an asset that could be sold by one company to another, or to raise their stock value, or et cetera. And so I just wondered if you've heard of that happening, and if so, the speculation that I just said, is that consistent with anything you've heard or seen?
I haven't heard it. I appreciate the information. It's something else to watch out for. I think the explanation that you gave is probably a good one. What we find, first of all, companies are going to have eminent domain rights to put pipelines across your land if you haven't leased. And it gets really absurd here because we encountered this in the city of Syracuse, where if you're classified as a public utility company, and these gas line companies apply for permission to become public utility companies, then they conduct the public hearing to determine whether or not they can get the pipeline. I testified at this is true. I mean, and so your question, your statement that the laws do not protect us couldn't be more right on. I testified, this was a dispute between just a horrible energy entrepreneur. A guy tried to build 2 clean coal plants. There's no such thing as clean coal, but he tried to, so he had an agreement with Syracuse University to provide them with steam. And because, and it was one of these cogeneration plants where 20 years ago the state came up with this great idea that we'll make sure that utility companies buy the electricity generated from cogeneration plants, and that will help us make steam and make electricity. Well, when Niagara Mohawk was purchased by National Grid bought out all those contracts. So this guy, Adam Victor, took $150 million to buy out, to have his contract buy out, and then he couldn't afford to make the steam that he had contracted to the university. So he attempted, he had a public hearing, his lawyer conducted the public hearing, he was going to condemn Syracuse University's pipelines and all the steam pipelines that went to all the hospitals in Syracuse. Well, guess what he found after the public hearing? Oh, we can condemn all this stuff. Now, he lost in the appellate division, but that shows you how little rights you're going to have when they want to put a pipeline across your property. And, you know, if they get gas in your neighbor's well, they've got to get it over to the major transmission line. That's going to be a pipeline. And it goes in a hurry, and it goes in by people, nobody watching them. It's supervised by yet another agency, the Public Service Commission. It's another way, and more we're seeing that the aging gas pipeline infrastructure in this country is fraught with danger. There was a terrible explosion last year in California where it went right under a residential community. People didn't even know it. I remember I grew up in Sandy Creek in northern Oswego County, and in the 50s when they brought the gas pipeline, we thought we'd finally become civilized. People would debate that in Oswego County, but because we didn't have to burn coal anymore. But that pipeline is now 60 years old. We have hundreds of thousands of miles of gas pipelines that are that old. They can't test the corrosion from the outside. There are disasters waiting to happen.
I'd like to chime in a minute. One of the other points that the gas companies do a lot of advertising, that gas is a green fuel and it's a transition fuel. And what Joe was just saying reminds me that, in fact, because of the leakage of methane gas from pipelines, from the point of pulling it out of the ground and getting it into a pipeline, etc., that leakage is so great that, in fact, if you look at the greenhouse gas impacts, climate change impacts of this kind of gas development, it looks about like coal. And again, they're not lying when they say that gas burns cleaner than coal. But watch what I said. I said it burns cleaner than coal. So you have a handful of gas and a handful of coal, and you're generating enough to light the lights. Yep, that coal is sort of twice as dirty. But look at what it takes to get the gas in my hand and to get the coal in my hand. They look about the same. Both of them are fossil fuels that are causing us problems.
My name is Gary Will. I'm from southern Madison County. In regards to the force majeure letter, does the company send it a year in advance, 2 years in advance of termination, 6 weeks in advance? Can you provide any insight to that? And then I have a follow-up question, please.
The only ones that I've seen, and maybe it's because in Onondaga and Cortland County, I live very close to the border, are the one letter that Chesapeake sent. And every one was dated January 26th of this year, which is within 30 days of the action by the governor. Now, I know that Cabot and other companies in the southern tier have sent force majeure letters as well. And so it seems to be more time to the action by the state than any individual lease, because they sent the identical letters to many, many different leases that had different terms, different periods.
The contract I signed with Arnott, I believe it was, Arden, and they sold it to Norse. Neighbors have gotten the force majeure, and I believe we all signed just about at the same time. I did not get a letter. Okay. Yeah, I hear you. But my follow-up question is this. Our lease is going to be expiring, the extended to the primary lease will be in 2013. I want to make sure I understand what you're recommending. You're suggesting that myself would go to the county clerk
in 2013.
In 2013. The first question is, how many assignees are on this particular lease? I don't know if I'm using the right jargon here. The lease. And then, at the same time, provide the county clerk with a letter saying, after I've already sent it to the company or the two companies, Arden and Norse, that this is terminated, we do not want to renew, and then file that with the county clerk. Do I have that in the right sequence?
Yes.
Okay.
Now the first question, I should have my notes up there.
Just to clarify, before you actually file that with the county clerk, you send it to the gas companies. They have 30 days to send something to the county clerks or to you saying we don't agree. And if you don't get their objection, then you can file that with the county clerk. If you do get their objection, various lawyers are saying you're going to have to take them to court. And as Joe was alluding to, this other attorney, Chris Denton, who has done a lot of lease work for actually some of the joint landowner coalitions, he's the one who sort of said, let sleeping dogs lie. The other thing he said was, if at some point in the future, so the gas companies haven't given you a force majeure, haven't told you that they're extending your lease, you haven't shaken the rug by telling them that that it's over, they haven't objected because you haven't raised their awareness of it, that he would recommend at some point in the future that you could file an affidavit with the county clerk that says, I never got any extension from them, I never got a force majeure letter, I never got any delay rental payments, this lease is over. And again, whether that's going to be enough, I don't know. It's a judgment call.
And your first question is, how do you know how many assignees there are, right? And the way you find that out is you go to the county clerk and you look up the original landowner that signed the lease. Look up under his or her name. Because if they filed an assignment notice or more than one assignment notice, it has to go to that name. And the reason I say that is that the gentleman that learned all this in Cortland the hard way, and took him from November to March before he got all the pieces in place and he was able to file those notice letters and the affidavit of service. He had to go back to the woman who owned the property. It had been a 10-year period in that lease because it had an automatic extension beyond the first 5 years. He had to go back to that woman's name, and that's when he found that Chesapeake had sold pieces off like they were used car parts. And so that's how you got to go to the county clerk, look at the name of the original landowner that signed the lease. Now, if you've taken the step of sending your deed, which you must do, otherwise they're going to extend your lease by paying somebody else, as we went over before, I would look under both names. In Cortland County, we have a very friendly clerk. We have pretty accessible records online. Onondaga County, you have to pay to get the records online. A lot of counties you can't. So you'd have to go over to the clerk's office. Usually the people that work in clerk's office are pretty helpful. They're elected officials, so hopefully they'll help you. And most of them have computers now where you can do a name search pretty easily. So you have to look at the original person who signed the lease, and that's how you find out whether it's been assigned or not. And it's not enough if you don't know about that. That's another flaw in that General Obligations Law 15304. It's an assignee either known or recorded.
Another word about the role of the county clerks, because again, I urge you to put some pressure on your county clerks. In Cortland County, Betsy Larkin, the county clerk, refuses to register, i.e. will not put in the land records, if a gas company comes and says, here's an extension of lease. She says, I'm only going to register that if it's signed by the landowner as well as the gas company. And they say, well, we're going to see our lawyer. And she said, this is what my county attorney tells me. And there's been some discussion among some of the wonderful lawyers who are interested in this issue. And basically, county clerks are only allowed to register certain documents. It's specified under the law. And in fact, one attorney has said, if a county clerk is registering extension notices that aren't signed by the landowner, he or she is acting illegally. Who knows? But it's certainly worth finding out. In my county, the county clerk is registering them. And she is registering them apparently saying, well, the gas company comes and tells me it's in the lease. Well, gosh, as we're seeing here, it ain't so clear what a lease really says about extensions. So I think the county clerk in Cortland has been courageous, and I think she's a model for us, and I would urge you to find out what your county clerk is doing. And if you want to and contact me, I can try to share with you some of the discussion. One other thing I wanted to mention, and Joe may disagree and weigh in differently, the force majeure deal. So you get a force majeure letter. We're extending your lease because of the moratorium. There's no doubt about it that you have to say something. The way the law works, as I understand it, is silence is acquiescence. You say nothing, it means you agree. So obviously, if you don't agree, you got to say something. There was a pretty lengthy response that Chris Denton had written going into the details of why that's a bogus claim. And in talking to a bunch of attorneys, they said, and in fact, Chris has changed his opinion, make it simple. Simply send a letter that says, hell no, we don't think so. And that such a letter, a template, is on the Fleeced website. Why keep it simple? A couple reasons. One, Chris noticed that when a client sent a fairly legalistic letter, they got back a challenging legalistic letter. When a client sent a homegrown letter, no, we don't think so, Jill Q. homeowner, they didn't get a response from the gas company. And so that puts you in a better position of not having to fight and take it to court at this point. The other thing we were advised by another attorney was if you lay out details in a force majeure response letter, it's possible that you will be held to that if you do take them to court later. And you may in fact find other arguments that you want to make later. So my inclination would be to keep it simple and just register your I don't agree, sincerely yours. And I don't know whether Joe agrees with that or not, but that's what we have on our website. There's no right answer, is there, Joe?
Well, it's time for the lawyer joke. We got to have a lawyer joke, you know. I was in Vestal about 2 months ago at a forum at a high school, first one in a high school. I really congratulated them for it. But they're in ground zero down there. They're going to come right across the border right away. And one of the, they had a landowner coalition leader there, and he said, you know, this is really good for jobs, and One of the areas of jobs that he listed is lawyers. So you can see that this is complicated law. You're up against major corporations. All they got to do is file a 2-line affidavit and you're in the hole. I don't think there's a simple answer to either that question. Probably better to keep it simple, it's easier. I don't think you're going to be bound by what you put in a letter in a lawsuit, but you know, that's the way lawyers make money. They disagree, and then they can charge you for it.
My name is Chris Barbish, and I'm from Afton if I'm paying school taxes, and Coventry if I'm voting and paying land taxes. Depends on where you're talking about, but that's where I'm from. And my question is, I have a couple of questions. One is, the lease that was signed was by my mom. She passed away about 2 years ago. So myself and my siblings are now saddled with this lease, which we're not really very enthusiastic about, and that's the nice way of saying it. Hate it would be another way of saying it. But one of the things that I question right away is that before Mom passed, I asked why I hadn't seen this particular contract, and she showed me a one-page contract that she had signed with the gas company. And I said, wow, this seems real odd and very, very short. One thing I noticed at the bottoms, it said something about a 3-day right of rescission. Now, without an entire contract to look at, I don't know how you could possibly make any kind of judgment about whether you wanted to exercise that 72-hour right of rescission or not. And I was wondering what kind of thoughts you had as far as any rights you would have beyond that if all they left you with was a one-page contract and you still had a 72-hour right of rescission. We eventually, I think about 1.5 years later, got a copy of the contract after requesting it from, I think it's Nornu, one of those two. What's your thoughts there, Joe?
Was that one page a memorandum of the lease? That's, they try to file those in some counties in order to keep the terms of the lease confidential.
Mm-hmm. This is actually what was left to my mom.
Okay, but she signed a longer document.
Oh, no question about it. Yes, her signature is at the bottom.
That's, unfortunately, I don't know of any rule that forces them to leave a copy of the contract with you.
Sometimes there's a lease provision. Sometimes there is a lease provision, you could look at it, about a signed copy being made available. And, you know, there's work for lawyers there, right?
I guess. But, I mean,
yeah.
I mean, if you try to sign up for a timeshare, they really make that 72-hour right of rescission much more explicit than they do on a gas lease that's worth infinitely more money, which is absolutely insane.
And you do have a 72-hour window. It's at the end of every gas lease now. Because of a law, I think they amended another section of general obligations law and made them put it in there. But you're right. How do you intelligently evaluate the lease over the 72 hours without the actual lease there? You can't do it. I think that would, here I go again recommending court, I think that in court that they'd have a hard time with that, but you'd have to have your mother around to testify to say, I was going to review this and couldn't and did everything I could to get a copy in 3 days and didn't. And it's a great example of how underhanded these people are. And I have a neighbor, we've met people who tell us, and there's no reason to disbelieve them, that the signature on the lease is forged. I had one neighbor who leased about 100 acres in Tully in August of, I forget the year, let's use 06. He wondered why he hadn't gotten a check, and the landman came back in October and he said, well, we calculated the acres wrong. Here's the same lease, we just got the amount of acreage correct this time. So Skip signed it. And he looked at them, and they're very, very different leases. The first paragraph where you give away your firstborn, I won't joke about mine, but firstborn, and it was a much longer paragraph giving much more things away, and it also contained a force majeure paragraph that was not in the original lease. And so that's the lease they sign. And to some extent, you have to understand these landmen are out there on commission, desperate to make that commission, desperate to file these leases. They don't much care, and the companies are willing to take their chances later on. Again, they want to pile up this stack of leases that they can sell them on the secondary lease market and make that $4.75 billion.
That's an interesting point you make as far as the secondary lease market. One of the analogies I want to make as far as my next point, my next question is, it seems like there's a material omission of facts. When these landmen go around with these contracts, they leave out unbelievable things that, well, you're going to be responsible if there's a spill on your property. And people would never sign these leases knowing these particular facts or these obligations would be, they would be obligated in this way, shape, manner, or form. Just as, and then the analogy I'm going to make is, there was, I think it was Goldman Sachs sold some mortgages to overseas investors. They all went down the toilet, and one thing they neglected to mention was that there was somebody else betting on the other side of these mortgages. So the SEC went and said, Goldman Sachs, you are going to be responsible for these German investors or whoever the heck it happens to be. And I'm wondering why there's nobody standing up for landowners at this particular point when these landmen go around omitting very, very important issues when we're going around signing these contracts.
We're wondering it too. And as I said, what is interesting to find out is it seems like it's not illegal not to tell you stuff. They don't have to disclose. It's not like a residential real estate transaction in which if you know that you have radon, you have to tell them. If you know that you have a water pollution problem, you have to tell them. This kind of a leasing transaction, they don't have to tell you anything. And as you saw from that talking point, they are trained to divert any questions.
My name is John Gatto. I'm up around Preston. What I'd like to know, my wife couldn't come here tonight, and she's going to ask me is, if we wanted to attempt to break the lease, how would we, what is the step-by-step procedure?
And by break the lease, do you mean that the lease is not coming to a termination on its own accord, but rather you want out?
It was extracted by fraud on the part of the Norwich land agent.
So that's what a number of us at Fleeced are wrestling with. And we have, with the benefit of an attorney, looked at a number of provisions in leases that may be grounds or cause for bringing a lawsuit and trying to get out of these leases. Peter Hudeberg was mentioning, well, we had been hopeful that there was a major law firm that might take a big case pro bono, and they decided that they wouldn't. And so at this point, we're trying to push on the Attorney General's office and see what kind of relief we can get from them. They probably won't take a case, but they may do something. That's one of the reasons we need people's stories. We need to know. And then Peter was just mentioning that there may be a possibility that if a number of us, whether it's 30 or 100 or 300, get together and we have similar enough cases. One of the issues is going to be that you signed with Norwich and I signed with Ansborough and you signed with Chesapeake. But many of these standard leases are very much the same, that we might be able to band together and put together a lawsuit and try and challenge. It will not be easy. And as Peter was saying, it would take some money. But frankly, I think for many of us, we would be willing to spend some money if we thought that there was a case to be made. And I think one of the things one has to be cautious about is if you bring a case and you lose it, you can make some bad precedents. So we'd want to be pretty sure that the case we were bringing had enough merit that we might actually win it. The case that's now pending in Binghamton that Joe mentioned is specifically on the force majeure issue. It's not, it does have some provisions that might have some relevance to the rest of us. But the case that we would have to bring to get out of our leases would be based on things other than the force majeure. And I'm delighted to see that you signed up for the fleeced list. I wish you had email. And I don't know if you know anybody, do you have a kid who lives in the area who does email? Because it's very hard to communicate with a lot of people if it's by phone. So if fleeced, and we'll talk further with Peter, if we believe that we may start building towards a lawsuit, we'll be in touch.
Thank you.
Let me just respond a bit on this. This is very much like the problem that we faced 3 years ago when we started learning about fracking. I don't think there's a legal answer to this. You're right. These things were fraudulently, every one of you knows what that landman or that woman did or didn't do when they came to that kitchen table. And they certainly didn't tell you that they were going to engage in fracking with 100 toxic chemicals that would come out radioactive and put it in open pits that are lined with plastic and that they're going to probably cause methane migration. They didn't tell you any of that. We're working, and so it's a political problem as much as it is a legal problem, because you as the victims of that should not have to pay for the cost of litigation to get out from under that burden. There's no doubt about that, okay? We can't find lawyers that will take those cases on, and there's a lot of problems with that because of the way contract law is structured. And every lease that I've seen has a clause that this is the entire lease, and nothing that was said on the side to promise you to get it matters at all. And that's a general term of contract law called parole evidence. There's some cases pending in Pennsylvania, and what parole evidence means is if you have a written contract, you can't introduce evidence about what was said to induce you to sign the contract. Terrible law. In Pennsylvania, their law allows you to submit proof about fraud. New York's doesn't. So the answer is much more, let's get the Attorney General in this. Why isn't he coming to the defense of landowners? And originally, when we started, and of course we have a change of administration, it takes them, in my experience, well more than 6 months to figure a lot of things out, so maybe we'll get them to do this. But their original response is, well, these are individual contracts, and we can't get involved until we see a pattern or practice. And that's why Ellen's advice to get the information, write the Attorney General. We're going to keep pushing him. We're working on getting some major publicity about this, national media about what's happened to people. One of the things that that's going to do is it's going to compare what they didn't put in your lease. There's nothing in there about risk and danger. And if you look at the SEC filings of the same company, they have to file quarterly and annual statements and advise their investments of the nature of their business and the risks in their business. If you look at what they tell their investors, I don't have that slide in this show. Maybe I should put it back in there. That's in one of my more general talks. It is scary. No one would sign a lease if they told you that, or you'd at least know that you were taking major risks. So I don't want to seem insensitive. Yes. Almost everybody who signed one of these had no idea how comprehensive it was in terms of what they were giving away. None of us had heard of fracking. We didn't know what it was. They did. They were doing it in Colorado. And so, no, it's not fair. And so the main thing is to keep organizing, getting more people together, getting pressure on the politicians that are getting paid, and that's the Attorney General. A couple of the Attorney General, back when Mr. Cuomo was Attorney General, they did reach a settlement agreement with Cabot Oil about their leasing practices, and they fined them, and there's some very flowery statements on the website about that. The reason for that is they were claiming force majeure when they didn't have it in their contract and they had them dead to right. They have been in negotiations with Chesapeake around leasing practices for over 2 years, and Chesapeake is telling them where to go. And there's not much they can do in that. Well, there is, you know. When he wants the headlines, he can go after somebody on Wall Street, but he's not taking care of the average citizen. That's what we went to tell them about a month ago. And we told them, politically, this is a good thing to do. You're taking care of citizens. Nobody's going to be upset if you protect the citizens, whether they're pro-drilling or not. At least they should get a fair shake, and you need to come to their defense. And we just need to keep on them and force them to do it.
Yep. Phil Morin from Sherburne, New York. My question is, projecting forward to the day when someone comes to me and says that they want to compulsorily integrate my property, would it be better, as I understand it, that process ultimately culminates in you having to sign something? It's actually a lease, right? Or you actually sign a document, a legal document, that you are agreeing to be integrated in a compulsory fashion? Is that true or not?
No, you don't.
That is not true. So
you're going to get into. You're going to if they approve that leasing unit and your land is in it, you're going to get integrated in it whether you do nothing.
Whether you do nothing or not. Okay. And then the question is, the next transactional opportunity, I guess, is when they give you royalties, or right, from the compulsory integration. Should you refuse that money? Does that give you any standing legally if you refuse the money and therefore there's no transaction?
No. You're given three choices. One is do nothing, essentially, and you get the minimum royalty. Not taking that minimum royalty is not going to keep them, here I go with about 6 negatives, they're still going to drill under your land, whether you take the money or not. So then you have the other choices of investing some, not getting your investment back or not. But
I guess the question
but
really,
not taking the money doesn't protect you.
It doesn't give you any protection.
It doesn't protect you, but if, perchance, you decided you wanted to do a lawsuit challenging compulsory integration, then don't take the money. Because then you would lose that ability to claim that I don't go there, I'm not going to do that, that's not okay. That's a different step.
Good evening. My name is Karen Given. I live out in South New Berlin. My name is Karen Given. And just to follow up on that, you mentioned that leased land would be liable for insurance and other liabilities. What about the people who are compulsorily integrated? Would they have, do you know?
I don't, certainly not on the first option, where you didn't invest anything. I think with the other two, once you become an investor in that operation, if that doesn't create liability, I don't know what would. Because essentially what you're doing then is agreeing, I'm almost positive, that you end up signing documents with the second two options. And so you're essentially leasing at that point and upping the amount of royalty that you would get. But that's something I'll look into further.
I just had a comment to add on that. It's my understanding that if you sign a lease, you cannot then, you give up your rights to sue if your property is damaged. So if you remain a passive non-signer, a person who is compulsorily integrated, and pollution happens on your property, you have a stronger case for a long lawsuit than if you became an active participant.
Joe, can you actually address that? Because I'm not aware in my lease that I have anything that says, and I can't sue them if they screw up my water supply. I am aware that there would be liabilities potentially if somebody puts a drill pad on my property or a pond full of polluted water, and some kid next door comes and swims in it and whatever. But I was unaware what Ken was suggesting, that basically I can't sue them if they screw up my water if I've signed a lease. Can you address that?
I don't think that's, well, first of all, certainly the terms of the lease could protect you better. I mean, I think we've learned by now we shouldn't be signing standard leases. I don't think you, unless there's a specific provision in the lease waiving your right to sue, I'd have some problem with that. But I would say that if you have a private water supply, a well, get it tested. Get it tested now and get it tested every year for 5 years. Because what the companies are doing is saying, that's not our gas in your well. That's not our benzene in your well. And we just, it's expensive. There's at least 8 indicators that you really need to test for. And those of you who have private wells and have tested know that every time you add a chemical or a compound to a test, the cost goes up. And around our lakes, and there are several of them around there, we pulled everybody together and brought the cost down. But if you don't have a clear, certified laboratory test of your well before they start, your chances of ever having successful litigation against them, that's what they're doing in Dimmock. Most of us have heard of Dimmock, Pennsylvania, where dozens of families don't have drinking water anymore. And those of us who live on wells know what would happen to our lives if you can't take a shower or you can't use your water. Your land and your life is gone. So at least get it tested. There are groups that have information about that, but clearly you want to do that. And I heard just recently that you should do it for 5 years. Now, obviously, start now, get it done correctly, and I'd say that that's one of the things that these volunteer groups can help do, because it does get less expensive as you get more people.
And one of the other, to me, injustices, the DEC, which should be there to protect us, is basically taking the point of view that, gosh, there was methane in these wells before all this drilling. There's lots of methane hanging around, and the fact that, funny, people's wells, maybe they had some methane in them before, I don't know, but have become unusable when there's been drilling around. DEC is explaining it away. So I do reiterate what Joe was saying, that some baseline testing, and you can't test for everything. The methane seems like a fairly straightforward thing, but again, one of the things when I was chatting with the DEC people recently, well, there was some water contamination issues in Horseheads with conventional well, gas well, and some polluted water wells. And the DEC person said, well, it's because it was so wet, there was a very high water table. So unfortunately, testing your well, today there's a high water table, but testing your well and having some history on it doesn't even necessarily mean that they're going to say when it turns up contaminated that the cause was the gas drilling. But it's probably necessary, it may not be sufficient. And there is something called the Community Science Institute, I think CSI, out of Ithaca, that has done a lot of looking into what should you test your water for. They actually do some testing. The guy who runs it is an honest man. I think highly of Steve Penningroth. So you might look there for what you want to perhaps have your water tested for.
Okay, I got 2 quick points. Number one, I heard through the grapevine that Norse Energy is filing Chapter 11, and how would that affect that you might want to fight or challenge to purchase your property back if all of a sudden they're losing it or something? How would that maybe play? Secondly, on our water rights, as they're trying to generate the statute that they have control of the water. One thing that has happened, I have a friend that has people in Dubai that control the oil tankers, and their water bill a month is $13,000 a month. And when they bring an oil tanker to New York City, They talk with the power authority that opens up the wells or the water channels in Pulaski and whatnot to let the Hudson come up on a time sequence. When they get the ship unloaded, they bring the ship up the Hudson and fill it with water to go back to Dubai. So now you get into this exchange. If we're $400 an average of expense of fuel per month and it's $4 a gallon, and they're $13,000 a month for water, and they're taking our natural resource back, who's getting paid for this, and how do the balance points come? So thank you very much.
The second point is, this is the way it's working. The first point was an interesting question, and I don't know if Joe has anything to add about it, which was that if Nornu is going into bankruptcy, is it a time that would be a good time to challenge things or to try and buy out your lease? One of the things I would urge you to do would be to go to the county clerk and find out whether in fact Nornu still owns your lease, because it may have been assigned, they may have sold it off as an asset, so you may no longer be dealing with Nornu, I don't know. Anything to add? Okay. All right, a last one.
Yeah, I checked the county records and found they extended my lease, and but I did not sign an agreement, the agreement that they asked me to sign. So I found, for what it's worth, that they did not register that lease.
Good. So your county clerk refused to register the extension of lease because you hadn't signed it? I
don't know whether they refused or Norwich just didn't send it in because it wasn't signed. I'm not sure. And the other item is that with seismic testing, they asked me a year and a half for permission, and I figured, well, if they're asking me for permission, then that means I can refuse. And basically, I came up with an excuse. I've been trying to get them to address some deficits in the lease to begin with. So I just said permission withheld pending resolution of differences, lease differences. And they've stayed away for a year and a half.